Okay, so, well, we know this, we've just started. So Migrant Democracy Project is, as the name suggests, an organization that is really interested in getting migrants in the UK participating in democracy. There are many of us here in this chat, and there are many of us across the UK as well. And this is our home, and that's why so many of you here in this webinar are interested in applying for British citizenship. So you can fully commit and make that the country your own, and continue living here with safety and security. And we also want you to make sure that you're participating in democracy however you can. So last week we went to Parliament, and we are meeting members of Parliament to talk about one of our key campaigns, which is about extending the right to vote. There are many migrants here in the UK who currently do not have the right to vote because of their nationality. So, for example, I'm from Brazil, but I also have British citizenship now, so I can vote. But if I only had Brazilian citizenship, sorry. Let me just stop sharing my screen. Sorry. Okay, my Google Chrome has kind of collapsed right in a bit, but I'll keep talking anyway. So our key campaign is we want to ensure that every resident has a right to vote. So we keep speaking to politicians, members of parliament, as well as local councillors and mayors, asking that they support our campaign for the extension of the right to vote. So maybe let us know in the chat whether you are someone who has the right to vote or not. And on top of potentially seeing the vote extended to every resident in the UK, another way that many of us can get to voting in the UK is by obtaining British citizenship. So that's exactly what Chris is going to talk to us about. But even without the right to vote, there are many ways that we can participate in democracy. All of us have the right to write to our politicians, to our councillors. There you go. My colleague has brilliantly shared the screen for me. And so, but some of us do have the right to vote. So Alex, can you get me to the next screen, please? So simply, if you are British, Irish, and Commonwealth, you can vote in every election here in the UK. That includes local elections for councillors, for mayors, and in general elections for members of parliament as well. If you are an EU citizen and you live in England and Northern Ireland, or any other of the nations, you have the right to vote in local elections, such as for councillors. Whereas if you are a citizen from any other nationality in England and Northern Ireland, such as Brazil or the US or Ukraine, you will not have the right to vote in any elections. However, if you are a resident of any nationality living in Scotland or Wales, you have the right to vote in their local and devolved elections. And of course, we want to see a more unified approach to voting rights, where no matter where you're from, you have the right to vote, at least in local elections. Next. So if you do have the right to vote, make sure that you are registered, because it's important that we're making our voices heard. And also, one of the practical benefits of registering to vote is that it improves your credit score in the UK, which is really valuable in a practical way. And if you have the right to vote and you're convinced, how to register is really simple. You go to a website called, that's www.gov.uk/register to vote. You click start now, and then it's going to ask a few questions about yourself, such as your name, your date of birth, your address, and where you live. And it also asks if you have a national insurance number. But if you don't have a national insurance number, don't be put off by that question. You can still click I don't have a national insurance number and still register to vote. Next. And if you then are registered, you have the right to vote, you have registered, the next step is to go and vote when there is an election happening near you. If you're in London, for example, the next election here in London will be in May 2024 for London Mayor, but there are always elections happening across the country, so it's good that you keep in touch. Next. And there are also valuable to know that when you go to vote, you need to take an ID with you that shows your photo ID, such as a UK passport, a Commonwealth passport, or an EU passport, as well as a biometric immigration document, a driver's license, and others that are seen here on the screen. But again, as I said, unfortunately, some of you at the moment might not have the right to vote, and we are campaigning for that to change so that you do have the right to vote. And as I said, that can be both by you taking part in our campaign for the extension of the right to vote, or by becoming a British citizen. So I'll ask you to join our campaign if you are interested, if you believe in this as well. We'll post a link in the chat to how you can write to your representatives asking that they support this campaign as well. And for now, I will leave you with Chris for him to tell you the process of applying for British citizenship and all else that you might want to ask him. So my colleague will stop sharing the screen and we can pass it over to Chris.
Thanks very much, Lara, and thanks for inviting me to come and speak this evening, and thanks for everyone, obviously, for joining in this session this evening, and hopefully it will be useful for you. Just to introduce myself very quickly before I start talking about the nationality process. My name is Chris Benn. I'm an immigration lawyer with a firm called Seraphus, and I work on nationality and EU settlement scheme and other areas of the immigration system. And so everyone who registered was asked sort of to provide a bit of information and some questions or potential issues that they've seen about applying to become a British citizen. Mostly we're talking about becoming a British citizen by naturalization, which is the process for adults. So those over 18 will mainly, if they're applying to become British, use a process called naturalization. There are some other categories which are a little bit more niche and less used. So nationality law being quite a big and complicated area. But we're going to talk about nationality by naturalization this evening. And I've gone through the questions. They're very good for drawing out the kind of the important information in the naturalization application process and some of the things that people need to be aware of. So to help, I have produced a slideshow, which I hope will be, I can put it into view here and just share my screen, but just bear with me for 1 second. Has that got, yes, it has gone on too. Excellent, I can see that. So I'll, and then what I'll do is I'll go through the presentation, and then we're going to answer questions, and we can be interactive, and if there's anything that you want clarified from the presentation or any fresh questions, then we'll try to cover those as well. So just a few things just to be very aware of about applying to become British is that it is a complicated area. There are lots of different potential applications that people can make to become British. Although, as I said, for adults, usually the process is called naturalization, but there are other ways of becoming British, which are a lot more specialized. And so it can sometimes take, it can be worth talking to a qualified professional to understand what is the appropriate process for you, because there are, like I say, so many complexities to it. The one that I'm going to talk about, naturalization, is, as I say, it's the most common one, and in certain senses, the more straightforward one. But of course, even within that, there are still some quite complicated parts to it. So, and I may not be able to cover every single scenario when I talk about that. Some of the rules when we talk about naturalization, they are absolute rules, and if you do not meet them, then you cannot apply to naturalize. Whereas some aspects of the criteria that the Home Office has are discretionary rules. And so what that means is that generally they approach it by applying the rule, but there might be certain scenarios where they waive or they apply a discretion to someone because of their particular circumstances. So again, it's important to know which ones are the absolute rules and which ones are the discretionary rules. If you are going to speak to an immigration lawyer or advisor about possibly applying for naturalization, then just be sure to make sure that they are a regulated advisor. And what that means is that they are qualified and have a professional regulator. And the reason that we say this is because providing immigration services is a regulated profession, and if people are not regulated appropriately, they are committing a criminal offence if they provide immigration services. And what that means is you won't be getting someone who's qualified to give you that information, and it can lead to all sorts of difficult situations where you may apply without actually meeting the rules, which is not what we want for people to be getting refused if they do make applications. Just the last sort of couple of points just to make is that when you do apply, because it is you are sort of proving that you meet the criteria to become a British citizen, and therefore the onus is on the person applying to produce the correct evidence to give to the Home Office and the right information so that they can check that you meet the criteria. So the responsibility is on the applicant to provide the information. And the thing I put at the bottom here on this slide is just about dual nationality, because it was one of the questions that came up quite frequently that people have raised, and that is about dual nationality. So dual nationality, obviously, just broadly me speaking, means holding more than one nationality. And the UK nationality laws, British nationality laws, are pretty straightforward about this. They allow for you to have more than one nationality. There are no real exemptions to that. If you want to become a British citizen, you do not have to forfeit an existing nationality. Or if you become a national of another country, you would not forfeit your British nationality if you've already hold it. So it's pretty straightforward. But on the flip side of that is, if you're applying to become British, you need to know that you wouldn't what impact it may have on any existing nationality or nationalities that you have, because I can't obviously cover that. The place to go would probably be to speak to your embassy if you're living in the UK, to talk to your embassy about what impact it could have, because all countries will have a potentially different approach to this, and so you don't want to lose your nationality if you apply to become British, if that's the consequence. So always check what would happen to your current nationality if you were going to apply to become a British citizen. Right. So quite often in sort of recent times, and obviously people were able to give their nationality when they registered. We have looked a lot about EU nationalities applying to become British. Part of the reason why is because of the referendum and the seismic impact it's had on the European resident population of the UK. The rules on British nationality apply across. They're not sort of different for anyone. They don't apply to EU nationals in a way that they wouldn't apply to non-European nationals. So they do apply equally. But what I have spent quite a lot of the last few years talking about is from the perspective of EU nationals who have been living in the UK before Brexit and have applied potentially through the EU settlement scheme, and then are looking about whether they want to continue on that journey to nationality. So that's why I've just added a bit of a slide about for those who have status under the EU settlement scheme. That's what EUSS means. Is it better to be British, or is it okay to stay with settled status, or what would happen for pre-settled status holders? Lara's already covered it in the context of the election position at the moment, and obviously for EU nationals with pre-settled or settled status cannot vote in UK general elections. So if you did apply to become British successfully, then that would change for you and you could vote. In terms of living outside the UK, if someone has a British passport, then there's no real time limit on how long they could live outside the UK for, whereas if you have settled status under the settlement scheme, you have a maximum of 5 years before you would lose your permanent status in the UK. So there's a difference in terms of how much time you can spend outside the UK. If you became British and you had a child born outside the UK, then that you could pass on British nationality to a child born outside the UK. Whereas if you had a child born outside the UK when you have settled status, that child is not going to be a British citizen. They may be able to become a British citizen, but they wouldn't be born a British citizen. In generally speaking, you can lose settled status and potentially you can lose nationality for criminal conduct. It's fairly similar these days in terms of losing the status for criminal conduct, which but there is probably arguably a slight difference there. But I mean, we don't want anyone losing any status, but that's the main circumstances where someone would lose either settled status, pre-settled status, or British nationality would be due to some kind of criminal conduct. Obviously, one factor, and again, it came up a lot in the questions when people registered, and the points barriers to nationality is the cost of it, because it costs £1,330 to make a naturalisation application today. That is a mandatory fee. Someone asked if there was any discounts for low incomes, if there's any opportunity to have a waiver of the fee for some people who wouldn't be able to apply at the moment. And the unfortunate answer is there isn't any leeway. It is that is the fee. The Home Office did recently address the issue for children applying to become British citizens, and did introduce what they call fee waiver for children whose parents couldn't afford it. But that was after a long series of litigation and pressure on the Home Office to change the position for children. That same pressure hasn't been applied for adults yet. That's not to say it couldn't change in the future. It would be nice to think that nationality could become a bit more accessible cost-wise for people. But if you're asking me today, what's the position? Could I ever make an application and have the fee discounted? The answer is no to that. And in terms of what happens if you applied unsuccessfully for British nationality, again, unfortunately, the fee is lost, with the exception of a small £80 payment, which is refunded, because that's the £80 that you pay towards a citizenship ceremony, that if you're refused, you wouldn't go through the citizenship ceremony, and so you get the £80 back, but you lose the main fee, which is really what people would obviously be concerned about. So it is expensive, and again, that's why it's really important to make sure, if you are going to go through the process, that you meet the requirements, so that you don't have that issue of worrying about being refused. If you do have status under the settlement scheme, one thing to be aware of, it's a little bit of a complex area of the settlement scheme, but for those people who so it would be settled status and then move on to nationality, British nationality, it can impact on your rights to sponsor family members under the settlement scheme, because there's a more complicated situation if you are a dual European and British national when you're trying to sponsor family members under the EU settlement scheme. It is possible, in many cases it is possible, but it is more complicated. So if you are, at the moment, if you have settled status and you are thinking that you want to sponsor some family members, but you're also thinking that you might want to become British national, then you would probably want to speak to someone like myself, a qualified lawyer, just to make sure that you're not going to limit your ability to sponsor your family members if you do become British, because it is a little bit of a complicated area. And I'm not going to try and explain it in this session, because really we're talking about nationality tonight, but something to be aware of. If you do think you're going to be sponsoring family members, then becoming British can impact on that. And I've said it already, I'll say it again because it's so important, is that check your current nationality or nationalities in case you do go to apply to become British, because you don't want to lose anything without, or you wouldn't want to be aware, or you want to be aware if you're going to sacrifice any existing nationality, so that you can make the right decision for yourself. Okay, so looking at the conditions, we have they're mainly set out here, and obviously I'll try and expand on the key ones as we go through. So naturalization is for adults, so it means people over 18 years or over, and when you come to apply for nationality, you have to be what's called free from immigration control. And what for the vast majority of people who are naturalizing, that means you have to hold in what's called indefinite leave to remain. Now, settled status under the EU settlement scheme is indefinite leave to remain. You'll see in the letter the Home Office sends to you when you get granted settled status that they say you're granted indefinite leave to remain. They've named it settled status to make it a bit easier for people to say it, but it is indefinite leave to remain. And every other people who've got indefinite leave to remain, you can get it through other types of immigration routes, like you could be a skilled worker and you could have indefinite leave to remain. You may have got it a long time ago. If you've lived in the UK for a long time in the past, you might have an indefinite leave to remain granted many decades ago. And there's some questions about indefinite leave documents expiring, which I will cover. But the point is that you have to have, in the vast majority of cases, people have to have indefinite leave to remain. If you're someone with pre-settled status under the EU settlement scheme, at this point in time, you couldn't apply for naturalization because the Home Office would say, well, that's time limited. It's not indefinite. It's a limited period pre-settled status. That situation is a little bit more complicated now because of a certain court case that happened at the end of last year. But for the purposes of tonight, we'll just focus on people who've got indefinite leave to remain. But if you have indefinite leave to remain, then you may have to wait another 12 months to apply for naturalization, because for most people, or quite a lot of people, there's a requirement to be free from immigration control, as the nationality law terms it, for at least 12 months before you make your application. So if you got granted settled status on the 17th of May, 2023, then you would be waiting until this time next year to make your application for naturalization. So that's the 12-month rule. You have to wait 12 months. Now, there's one exception to that, which is if you are married or if you're in a civil partnership with a British national, then you do not have to wait those 12 months. So again, if I was granted settled status on the 17th of May, but I'm also married to a British citizen, then I could say tomorrow I'm going to apply for naturalization. I don't have to worry about waiting for those 12 months. So that's one of the conditions that you have to assess, because there's two options depending on your situation. You have to have capacity to consent, so you have to be aware of your making an application. Again, most people, the vast majority, will be able to meet that. There is what's called the residency criteria. So the residency requirements. Now I've put 3 years and 5 years there again because there's a slight difference, because if you are married to a British citizen or in a civil partnership with a British citizen, then the application will look at the last 3 years of your UK residency. But if you're that person who has waited for 12 months because you're not married or in a civil partnership with a British person, then the Home Office looks at the last 5 years. And when I say it's counted back from the day you apply. So if you apply today, we look back 5 years, or we look back 3 years if you're married or in a civil partnership with a British person. So this is the residency conditions, and I'll expand on that because that's one that people often want to understand a bit more about. You need to show that you can speak English and pass the Life in the UK test. And again, I've had some questions come up about that. Now, someone I think asked a question about being exempt, about if someone's 50 or 55. The exemption, unfortunately, doesn't kick in until you're 65. So if you are over 65 when you apply, then you do not have to prove that you can speak English, and you do not have to pass the Life in the UK test. But for anyone under that age, when they apply, you do have to do those things. The Life in the UK test it's a bit of a yes or no. There's only one Life in the UK test, and you either pass it or fail it. And you can take it as many times as you want until you pass it. But hopefully people can pass it first time. There's like a book, because the the test is drawn from a pool of questions, so the book will cover most of the questions that would arise. So if you study the book, then you'll have a good chance of passing the test. But it is a bit of a yes or no. And the other exemption, sorry, I've said there's an age exemption. There's potentially an exemption if people are sort of medically unable to take the test, but that's quite sort of a strong situation. It's not very often that people are considered medically unable to take the test, but if someone could show through doctors or specialist medical evidence that they are, then they could be exempted. But otherwise, you will take the test and you do need to pass it in order to progress with your nationality application. Of course, that's one of the first questions I ask people when they come to me: have you taken the test? Yes or no? The answer is no. I say, well, let's book that test in because you'll need it for moving the application forwards. English language is a little bit more complicated, not in the sense that, I mean, everyone has to show that they can speak English, but there are different ways of showing you can speak English. So, for example, there are what the UK considers to be English-speaking countries, like the USA and Australia. So if you're from a country, and there's a list of countries, I'm not going to go through them all, but there's a list of countries, and if you have a passport from that country, just a passport, you don't have to have lived there, you just have to have a passport from that country, then you will be deemed as someone who speaks English because you're assumed to have grown up speaking English. If you're not from one of those countries, and obviously most EU countries do not speak English as the first language, but they speak English extremely well as a second or third or fourth language, but you have to prove in another way to the Home Office. So there's things like if you've done your studies in the UK and you've got a degree, undergraduate, master's, PhD, then you could use that to show that you speak English to the acceptable level. In some cases, if you've studied in English but not in the UK, you can get a confirmation that your course was taught in English and that again you speak to the appropriate level. Or for quite a lot of people, it will be what's called taking an approved English language test. So the Home Office has a list of approved English language providers, and you can contact them and say, I'm going to apply for citizenship, and they have the test that is appropriate at the appropriate level, because there are different tests for different immigration applications. So if you do have to contact a Home Office, as I say, make sure they're approved by the Home Office. They have to be. Even if you speak fluent English and you've got a great test from a really good English language school, if they're not on the Home Office list, the Home Office doesn't care. They just say, no, that's not on our list. So make sure they're on the list. And when you contact them to book the English language test, make sure that it's clear that you're doing the test that's for the naturalization application. They are all familiar, the language centres who are approved are familiar with the different levels, but that will get you at the right level. And all this information, there is good information on the gov.uk website about the criteria that I'm running through, and there's hyperlinks through to approved test providers and so on. So, the gov.uk has had quite good improvements in recent years to try to get this information a bit more clear for people. But yeah, so the English language life in the UK test. And then there's this sort of slightly strange requirement for people to intend to live in the UK permanently, which is not exactly a very clear statement of what does that mean? What's permanently? What does intend mean? And so just to say, the reason that I've put an or at the end of that bullet point is because if you're married to a British national or a civil partnership with a British national, you don't have to show an intention to live in the UK. That criteria does not apply to you. But if you're not in that position, then you have to say, I do intend to live in the UK permanently. So how does this get assessed in the application? Well, the guidance that the Home Office has is essentially says, if you meet the residency criteria, so in this case that would be for 5 years, that would be the 5-year residency criteria. If you can meet that criteria, then we will assume that you intend to live in the UK, unless we see something which clearly indicates that you don't intend to live in the UK. So if you wrote in your application form that you didn't intend to live in the UK, they might decide that they question that particular criteria. But generally what it means is you're not expected to go beyond showing that you've been resident for 5 years in terms of proving your intention to live here. So that's that particular requirement. And then the last 2 points to make is about having referees. And again, this is something that was put in the registration form about people struggling with referees. So I'll come back to who can be a referee. But it's about confirming your identity. It's not a character reference, by the way. It's not saying this person is worthy of becoming a British national. It's not an assessment of you as a person. It's simply, this is the person who is claiming to be this person is the right person who's making a nationality application. So it's to prove that you are who you say you are. And they have to sign your application off. And then the final point is there's something called a good character requirement, which is essentially mainly to do with criminal convictions and issues like that, but there are other aspects to it. It's not always about criminal convictions. It can be about associations for people who are potentially high profile and are considered to be sort of not have good publicity surrounding them. So that it is far broader than just about criminal convictions. It can sometimes be about previous immigration breaches or issues to do with immigration law. So it's quite wide ranging, and I think it's one of the risk elements for applying. I think it's one of the factors that leads to the most amount of refusals. I believe is to do with good character, but. Again, we've had a question about good character, so I'll try to come back to it. But if you think, essentially, particularly if you have any kind of offending history, then you absolutely need to sit down with someone and go through whether or not you can meet the good character requirement. Because what can happen is today you may not be able to because your conviction is recent, but over time in the future, it will be several years usually. The conviction is sort of taken off your record, and then you can apply. So if you have anything in any that issue to do with that, then do speak to someone, because as I say, it's a higher risk of getting refused. Okay, so that's the criteria. And again, I'm going to come back to a couple of those points as we go through. The process of applying, which again was something that people flagged when they booked onto this evening's talk. How do you apply? Well, so you mainly apply online. There is the option to apply with a paper form, but I think most people find it easier to apply online. So you do it through the gov.uk website. If you Google today, naturalise as a British citizen, naturalise as a British national, you will come up with the gov.uk page that sends you through to the online application form. So you register, you give your email address, you give a telephone number, it will send you various security verifications so that you can then log into it. You don't have to do it all in one go. That's quite handy because sometimes you don't have all the information. So you can build up through the application. And you'll see the application it obviously asks you about your identity, it asks you about various aspects to do with your immigration status. So if you've got settled status, it will ask you for the reference number of your settled status. So it asks you your addresses. I think it covers the last 5 years of addresses it asks you for. So things like that. Again, none of it should be too tricky to answer, hopefully. So you do the application form, and then when you get through the application form, it will ask you to pay the fee, and then once you've paid the fee, if there is documentation that you need to upload with your application, you can upload scanned documents and PDF documents, JPEGs, as part of your application, and then it will usually require you to go and have what's called a biometric enrolment appointment, and that means essentially there's various visa centres around the UK where they can take your fingerprints and take a digital photograph of you. And that is a necessary part of this application. Again, for European nationals who've gone through the EU settled status process, the EU settlement scheme process, you would have been able to use your phone to scan your passport, and that was a good part of that system, but it doesn't apply to the British nationality applications. These applications still require you to go to a visa enrolment centre to give your fingerprint information. And the Home Office is, if you've done that before, if you've had to do it, because if you haven't gone through the settlement scheme, or if you're non-European who's gone through the settlement scheme, you would probably have given your fingerprints to the Home Office in the past. And so the Home Office is trying to reuse, as they say, reuse the biometric information to make sure that people don't have to do it too many times, or even more than once is too many times. So it's possible that if you've done it before, then the process says actually you've done it before, you don't need to do it again. But for a lot of people, and particularly Europeans who've got settled status, you will have to go and do it. So you do, once you've done your biometrics, assuming that you have to do a biometric appointment, that is the application process complete. So stop there, you've done it, you've paid for it, you've submitted it, you've uploaded your documents, your evidence, it goes to processing. Now, the Home Office has a sort of time frame of 6 months. That's the service standard, it's called. So what it's not saying is we guarantee it within 6 months, but it's saying when things are operating reasonably well, we do the vast majority of applications decided within 6 months. And I think that's fair. Like we've had COVID blips where things took a lot longer. There have been strains on the Home Office because they introduced Ukrainian visa scheme because of the invasion. And that certainly put a strain on their resources, and I think an understandable strain on their resources. So decision times were longer than they would have liked to have been. I think we're getting back to more normality now. If your application goes over 6 months, is that a terrible sign? Not necessarily. It can just be the nature of things. You can contact the Home Office after 6 months. They're unlikely to sort of give you a breakdown of why it's taking more than 6 months. They're not going to say, oh, it's this reason or that. But they will say, well, it's still being processed. But if all going well, fingers crossed, within 6 months you'll hear the decision, and the Home Office approves. And like I say, fingers crossed, that's how everyone gets the result of an approval. Then the Home Office tells you to go to a citizenship ceremony, and these are organised via your local council, local authority. The details of your local authority are given to you when the Home Office issues you the approval. And you're supposed to do that within 3 months to go to a citizenship ceremony. And what this is effectively like, generally it's a public ceremony with other people who are also going through the naturalization process, where you will be asked to, I think it's nowadays called an oath of allegiance to the monarch. And essentially there's a sort of presentation. I think some councils and local authorities, you can do it privately if you pay them to do so and things like that. So, but ultimately it is part of the process. There's no option to say, I don't want to do the ceremony aspect of it, because you're not British until you've done that, because that's when you'll receive what's called the certificate of naturalization. That's when you've gone after the citizenship ceremony, you'll get your certificate of naturalization, and at that point you are British. And sometimes you say, well, do I need a passport at this point? Do I have to have a passport, or is the certificate of naturalization my British proof? And so in terms of legally speaking, the certificate of naturalization is your proof that you're British, but you are not going to be able to travel on that. You're not going to use it to go on holiday somewhere, because you'll need a passport. Now, you may already have a passport. And again, that's one of the questions I think I'm going to come back to about what happens if you're trying to get a British passport and you need to use another one. So I'll come back to that. But basically, legally, you're British with the citizenship certificate, the naturalization certificate. Most people will go on to apply for a British passport purely for the travel and being able to show it when you need to prove that you're British, because it's an easier way of proving you're British than a certificate of naturalization. Anyone who, sorry, and this point down the bottom is very important, is anyone who has been given a Home Office residence card or residence permit. And again, if you're under the European EU settlement scheme and you're European, you won't have this. But if you're under the other parts of the immigration system, or non-European under the EU settlement scheme, you will have a residence card from the Home Office, and you need to send that back to them. There's instructions to cut it up and send it back to them within 5 working days. And if you don't, then they can fine you, because obviously you don't need it anymore because you're British. So you don't have the immigration status that you had before you became British. You don't have it anymore, so you don't need the permit proving this. So that's the application process. I'm going to just cover a bit of the residency conditions now, because this is quite a key element of the criteria that you need to meet. And as I've said, because some people are using 3 years of residency if they're married or in a civil partnership with a British citizen, as I've said several times, you're looking at 3 years. And if you're not in that situation, you're looking at 5 years. And what happens is you get an allowance of time that you can be outside the UK. To meet the residency conditions, you get an allowance of time, and if you are under that time, then the Home Office says you've met the residency conditions. So I'll take the 5 years because it's the most, because most people usually are applying with the 5 years of residency. So what happens is you get within your 5 years, you have 450 days of absences from the UK. So in your head, that's about 90 days per year, 3 months per year. But you don't have to always spread it evenly across the 5 years. That's something to bear in mind. But you have these 450 days. That's the first condition. And the second one is that within the most recent 12 months, so again, working back from your application date, which is taken from the day you submit the online form to the Home Office and you pay the application fee, in the last 12 months, you shouldn't have gone over 90 days. So the 90 days is included in your 450-day allowance, but in the last year, you shouldn't have gone over 90 days. So to try to break that down into a bit more of a straightforward example is that if you take your 5 years, in year 1, if you took no trips, you would have had 0 years. And in year 2, you could have had 180 days. And so over 2 years, you've basically had 90 days per year, but it all happened to be in year number 2. So that would be okay. But if you then move that scenario to the last year before your application, so year 5, so if you had no absences in year 4 and 180 days in year 5, then you couldn't move 90 days into year 4 and say that's okay, because in the last 12 months before your application, you would have exceeded the 90-day allowance. So like I say, there's a bit more flexibility with years 1, 2, 3, and 4. In the last year before your application, year number 5, that's when you have to have a little bit more of a look at how long. Now, the application form asks you about your absences. It asks you to list your absences. So it asks you to list your trips outside the UK, which some people obviously say, I have no idea. I don't know. I don't have records because I don't have the exact dates over the last 5 years. And that's quite common. So what I always say to people, and it's reiterated in the Home Office guidance, is you have to do your best. You have to try to work out your absences over your period so that you can record them in the application form. If you have a lot of travel, there won't be enough space in the application form, so you have to try and produce something like an Excel sheet that you can then sort of turn into a PDF document or just a table in Word that you can list everything, because you have to try to give the best answer that you can. If you really are unsure, then you can declare in the application form, I've done my best. This is what I think is my absences, but there is, I'm not 100%. So that's how it is. So you have to do your best with the travel. You don't have to prove it in the sense that if you say, well, last year I was away from the 1st of July to the 15th of July. You don't have to then produce a travel ticket that shows that. You're not being asked to do that. You're just being asked to list the information. So do your best. If you're going to go over the limits that I highlighted, the 450 days in 5 years or the 90 days in the last 12 months, then what you need to look at, again, you probably need to then come and speak to someone in my line of work to understand whether the Home Office might apply a discretion to you, because this is one of those rules where there is quite a lot of discretion. It's not a binary yes or no. So the Home Office has a policy in their guidance document that says, look, this is how we will assess your situation if you've gone over the normal allowances. You know, these are the normal ones, but you might have gone over it, and there might be a good reason. And obviously COVID, like that really made a bit of a mess of people's UK residents if they had to leave, because it took a long time to come back, or restrictions were in place and so on and so forth. So people have been affected by things which should be way beyond your control. And you might say, well, I still want to apply to naturalize. So there will be things like COVID, but it doesn't have to be as dramatic as COVID. But there are things that the Home Office will say, well, is there a reason why you've gone over the allowance? Or in some cases, they just say, well, if you meet everything else, we will waive this one requirement. And so it's an assessment that's based on their policy. So I can't sort of give you every scenario where they might allow extra time out, but if you calculate your time and that's where you end up saying, oh, I do look like I've gone over, then talk to someone to see how you can present that information. And if the Home Office looks like they'll apply a waiver or they'll apply their discretionary policy. So to give you an example, like of how there is quite a good amount of leeway, I would say, is that it's only in the guidance, it's only when someone goes over 900 days, so double the amount that they give you, that's the point where the Home Office says, well, usually we wouldn't grant this. I mean, even then it says usually we wouldn't grant this. So you can see that there is discretion, but something under that, you may be able to make a strong case for yourself. So it's always worth talking to someone. It's not the end of the story if you've gone over the allowances. That's what I try and emphasize. Talk to someone who knows it and go through whether you can succeed. Okay, and yeah, so lawful residents, because it's not just residents, it is lawful residents, and this was a real problem up until relatively recently for European nationals, because of some sort of complex free movement law background that I don't want to take up everyone's evening with, because I'm already taking up a fair amount of your evening. But just to say that until recently, the Home Office was sort of asking European nationals to show that they were living in the UK under EU free movement law before they applied under the EU settlement scheme, which for some people was quite tricky, particularly if they were what's sort of described as economically inactive. And because the Home Office was saying, well, you needed to show that you had some kind of health insurance if you weren't relying on the NHS, if you weren't paying taxes. And it has a long controversial background, that approach. And thankfully, I'm pleased to say, after a lot of campaigning by some very, very good people, one of them that was dropped, and the Home Office agreed that people didn't have to explain their position. European nationals and family members of European nationals didn't have to show that they were using free movement rights to live in the UK. So it's become a lot more straightforward. So essentially, the Home Office guidance will now say to you, if you have indefinite leave to remain, and again, that includes people with settled status, then we're not going to go any further into your background. We're not going to ask you to produce documents about having private health insurance or if you're making sure you are working all the time. And that is actually one of the questions that someone has asked, and it's a very good question, is, do I need 5 years of tax returns? No. nationality is not just for people who've been working. It's for the criteria that I've talked about. None of it is to do with people having to show tax records and employment or self-employment. So yeah, essentially now the Home Office is, if you have indefinite leave to remain, including settled status, then that is sufficient for us to accept that you have been resident lawfully. So that's good. It's a big help. It took a long time to get there. The reason I've put down the last bullet point on this this page about the good character requirement looking at 10 years is just to flag a little thing where I would argue that there's a bit of an inconsistency between the Home Office saying we don't look further back than 5 years, when actually, if you look at the good character requirement, it does say, well, sometimes we could look back over 10 years rather than 5 years. So it's not to worry people unnecessarily, because particularly with European nationals, this really would be very unlikely to cause any issue, because almost all EU presence, nationals being present in the UK in the last since for like decades, has been under European free movement law. So there probably is no reason to go any further back than the 5 years. But just to say, for some people, if you've got to your settled status via a different route than the EU settlement scheme route, if you've got to, your indefinite leave through a different route, maybe a refugee status, something along those lines, this 10-year rule can sometimes affect what the Home Office might look at. So again, sometimes just to be sure, it's worth talking to a qualified person. But generally, if you've got indefinite leave to remain, the Home Office is saying that's fine. That shows us that you're lawfully resident for the period that we need to look at. Right. So referees, I'll just to explain, because again there was a few questions about referees, so you need 2 referees each application, and the rules are basically as I've set out here. 1 referee can be of any nationality but must be a professional person, and the other person must be the holder of a British passport and either professional or over the age of 25. And then there are rules about the referee, basically, so it cannot be related to you. So if you're someone who is married to a British citizen, then they cannot act as your referee in the application. So I think most people struggle with the professional referee. I think if people are going to have an issue, it tends to be with the professional referee. Now, first of all, who is a professional referee? Well, the Home Office has a list, again, in their guidance, which I've got links to at the end of this presentation. We can always provide those. There's a list of professions that the Home Office says, well, if you're on this list, this is fine. So that's the first thing to check. So ideally, there is someone on there that you can use. But I am aware that sometimes people can struggle to produce that professional referee. What do you do if not? Well, the Home Office rules are that you produce a professional referee. Again, it's presented in a very binary way of, if you either do or you don't have someone who can sign off your application as your referee and that they're professional. I don't think I've ever seen an application not succeed because of the identity of the professional or the identity of the referees. I've never, in my experience, had it come back as an issue, but that's not to say that it couldn't. So you have to try to work within, obviously, the parameters that they have set. But the first thing is to look at the list of professions to see if you can identify anyone on that. Okay, I think, yeah, so as I said, there's just some good guidance, which I've got links to, but if there's an easier way of distributing these links, I'm sure we'll find out. But I'm going to stop there because I hopefully covered the main topics that people flag, but I do know that there are some slightly more detailed questions, which we will also attempt to answer in the next section. But I'm going to hand back to Lara for a little breather from me.
Thank you, Chris. That's been amazing. I've been getting texts from people that are on their phones that are saying how amazing this is. People on the chat are saying that's very helpful. The Q&A as well. I know some of you are down as me. You've got your name. My name is you, but it's fine. I know that it's not just coming from me, the praise. And yeah, we do have some more questions. One, I've been able to answer some. But one that we've got on the chat is, well, which you kind of touched on, but I think your guidance on this again is important, whether it's okay for someone to do the citizenship application on their own, or if it's better to do it with a lawyer.
Yeah, it's a really good question. I think, I mean, there's no right. Okay, so there is no definitive answer to this question, because it will depend on a number of things. So what I would say is, if you've identified from what I talked through, and particularly if you then go and look at the guidance, the Home Office has several guidance documents. Unfortunately, this is the way that they work, where they have what's like a public facing one on gov.uk, and then they have a slightly more detailed one, which is called a booklet, and then they have what they call their caseworker guidance, which is much, much longer, which is the one that lawyers like me will go to, because obviously we have to work with this. But if you identified from what I covered as the criteria and said, actually, I think that sounds like me, and I'm pretty good, happy that that's where I'm at, and then you maybe look at the gov.uk, and then probably the booklet, the what's called the AN booklet. And if you said at the end of that, yeah, I think that that's me, I'm pretty happy I can do this application, then I would probably say, yeah, do so. If there's anything in that I've talked about where you said, when I was saying this is a bit more complicated, and if you identify yourself in that kind of bracket, even if you still think, actually, no, it sounds like I'm still okay, but it sounded like I'm not as quite as straightforward, that's when I start thinking, well, you might want to talk to someone. And you know, within law firms, again, someone helpfully with what they put when they registered about, there used to be like this service called nationality checking by the post office, where you could pay them sort of £80 or something and they could check it. They don't do it anymore. But then, so for example, my law firm will check an application. We won't do it. We will check it for you. And there's other law firms. I'm not saying we're the only ones that do it, but there are law firms who will check through an application for you and say, yeah, you can submit this by yourself. So you've got that kind of reassurance. And then there's ones where sometimes people can come to me and say, oh, I've been outside the UK for really over the normal limits, but I want to do it. Can you put together the argument for me? And of course, in those scenarios, that's where we would do the whole thing and make the arguments based on discretion. So that's why I say there's no right or wrong answer. So, but I think I guess I would go back to the point at the beginning, which is that it's a non-refundable expensive application, and so certainly people I work with have said, I just want the reassurance that it's going to get through, because I don't want to have to do it more than once. And in that case, then having a lawyer was the right thing for them. But it will always, like I say, it sort of depends. So hopefully that.
Yeah, I think depending on as Chris said, if right now you've seen that your application seems all good, you might have a little bit more confidence. Whereas if you picked up that there are some questions that you're still wondering, that you're not super confident on, then there are people out there, including Chris's organization, that can definitely help. Chris, someone asked if after they looked at the list of referees, they still can't think of anyone that they know to be their referee. What steps can they take to just find someone?
You'll see from my face that that's not a question I have a good answer for. I don't know. As I say, I think the thing is, and this is why I have to reiterate, is my job is to say, well, what do the rules say? What are the rules telling you need to do? And the problem with the referee list, as far as I'm aware, is that there's nothing that I've seen in the guidance which says, if someone can't find them, then this is what they should do. You just don't have that. There's an assumption that you can find someone on that list, or if you don't know them now, you can get to know someone on that list. who can do it for you. And so that's the problem. So I don't, as I say, so the solution, I'm afraid, is for me is not to say, well, just disregard it and apply because there is nothing in the Home Office's information which tells you that there's an alternative. As I say, I have not seen an application rejected on the basis of the referee not being appropriate, but that's not to say it doesn't happen. It's not to say it couldn't happen. But I'm really sorry for not having a better answer, but I don't have one.
That's okay. My colleague has put a link above here in the chat with the list of acceptable referees. And you'll see that one of them is a counsellor. All of you have the right to contact your local counsellors. Usually counsellors hold surgeries as well, where residents can go and just ask general questions. So that's one person in your community who you can get in touch with. You can make yourself known to them, and they could potentially be a referee. I can't guarantee that they would, but it's a person in your community that could become known to you. And well, I think you answered this, if there's an age limit on the English test, which is, Chris said, if you're over 65, that you're exempt from having to do the English test. And this a question.
Sorry, I should have said 65 or over. So if you've just ticked over to 60. No, I was thinking when I said it myself, I was like, do I mean over or no? 65 and up. So.
Great. Yeah. Yes. Thank you for clarifying that.
No, clarifying myself.
And if an application is rejected, can someone appeal, or do they have to start the process again? Right.
That's a really good question, actually. So if you're rejecting, I think someone said there's another question about, do they tell you why? So yes, they do. They have to explain it. Like good legal decision making requires you to know what the basis of the decision is. So yes, they do tell you. There is the option to apply for a review. So it's you basically pay the Home Office to review the decision, and at which point you can provide additional information. And then, so what they will do is they'll take into account anything extra that you provide with the initial one, and they'll say, did we make the right decision the first time around? And so you can do that. If the decision on review was to say, no, we still don't think you meet the rules, you don't have any right to sort of a full appeal, which in the immigration context, when you appeal a decision, you go to something called the Immigration Tribunal. So you don't have that right of appeal with a nationality decision. The only appeal you could make is something called a judicial review. So that is essentially you're going to normally a high court or an upper tribunal judge, quite a high level of judge, and saying the Home Office just they've irrationally made the wrong decision. That's the kind of thing you say, or they've unlawfully arrived at the wrong decision. So it's a very difficult challenge to win. It's not straightforward, and it can be very expensive. You can be liable for Home Office costs if you don't win the case and things like that. So it's not something to be taken lightly. But that's the way it works if you're told not. And some people, I suppose, it also, so whenever you're looking at trying to review or appeal a decision from the Home Office, of course, the first thing again that you do is you say, well, what's the chances of this succeeding? Because let's say you made an application and didn't give or you didn't take the life in the UK test, and you weren't 65 or above, then the Home Office says, well, you didn't take the life in the UK test, so we refuse you. There's no point in trying to review that decision. There's no point in going to a judicial review about that decision, because it's the correct decision, because you didn't do something that you didn't provide them with the right evidence to show you met the criteria. So in that scenario, you would have to say something, well, sorry, you need to apply again. But in other cases, like I can, the thing I can think of, the ones that I've dealt with, which are complicated, and they're not your normal types of refusals. So It's a bit hard, but it may be. Essentially, if you submitted all the documents and the Home Office says, well, you didn't give us the life in the UK test, then you would clearly want to review that decision and say, I did, and I do meet the right criteria, and so review it, grant me, and then you would probably then pursue a sort of complaint about the fact you'd had to then pay an extra fee. So that's the kind of thing that would potentially succeed on review. So that's how that would work in terms of challenges. Again, it just depends on the reasoning.
Yeah, I think that makes sense. Thank you for giving us the examples. And there's the question as well on the COVID exceptions. You talked about how long someone can stay outside of the UK for, and that there are potential exemptions due to COVID-19. Do you know how likely is it for the Home Office to accept these as exemptions?
Yeah, I mean, it's the answer to the question is yes. My firm has quite I would probably say quite a lot of the naturalization work we've done over the years has been about dealing with the norm, going over the normal allowances. And so within that, there would be COVID reasons and there'd be non-COVID reasons. So it's very evident to the Home Office has been reasonably quick and reasonably good to accept that people whose lives are in the UK and never intended to leave the UK for long periods and have always, clearly intend to continue living here post-pandemic shouldn't be disadvantaged by what happened during the pandemic. So the Home Office understands that as the overall approach. That's not to say there aren't difficulties within this sometimes. So if someone says, what they do, again, without trying to go into it in huge amounts of detail, but when someone exceeds the absences allowance, one of the things that the policy tells you to do is to go back and look at the period before 5 years began. So if we're looking at someone with that 5-year qualifying residence period, then the policy says, well, have a look at a couple of years before that and see what the person was doing then. Because if they were kind of living here, because then we can see a longer pattern of whether they're living here. So if you're someone who has you have your 5-year reference and COVID's bang in the middle of it, and it caused you to go over the absences allowance, if you then go back a couple of years earlier, so you look at 7 years rather than 5 years, if it's clear that the COVID part was an anomaly, like it was normally you're here, you have 4 weeks outside because of your holidays or kids or school, whatever, and then there's this one bit in the middle that's to do with COVID that took you over the absences allowances. I would argue in most cases the Home Office is going to be very clear that you're going to get a discretion granted. I mean, I'm not saying that unequivocally, but that's how I would want to argue it, is to say this is a one-off. If you're someone who is before COVID was over the allowances as well, and then is over because of COVID and really doesn't ever have a period where they come under the allowance, then that's when you're going to have a bit more of a tricky time arguing. But it is always facts. It's always fact. This is why we can't do this sort of individual advice. But yeah, but no, there are plenty of people who will succeed by saying, I was away over the absences allowance purely down to COVID and restrictions.
Again, very clear. Brenda as well says thank you. So good answer.
Thanks, Brenda.
And again, on the topic of rejection, so if you are rejected, do you need to wait a certain amount of time to apply again, or can you do it straight away?
It depends. So if again, I suppose examples are probably the best way to do it. But if again, my person who was very unfortunate and didn't apply with their life in the UK test, if they are there refused, then as soon as they have the life in the UK test, as long as they meet the other conditions, then they can apply again. If you're someone who has been refused because of a criminal conviction, then it will depend, because what the Home Office does is they in most cases they use something called the Rehabilitation of Offenders Act. So you know when you're if you've got a very, very serious criminal offence, the likelihood is you're not going to ever get British citizenship, because they won't grant it to people with very serious offences. But if it's you serve a period of imprisonment for an offence, there is a time that you wait until you can apply. So if someone applied too early, they didn't realise about waiting, and they applied too early, and they came to me, what I would say to them was, well, no, we have to wait until that time has passed, because every time you apply whilst the time hasn't passed, you're going to get the same outcome. But once the period has passed, as long as there's nothing else there that we need to worry about, then you're okay to apply at that point. So in those cases, you have to wait. So it will depend on why you weren't successful as to how quickly you can remedy it. And again, if there's someone who's got too many absences, then and they can't be justified for some reason, if there's just too many of them, then what I have done for people is work out and say, well, as long as you live in the UK from now on, you'll be able to get under the absences by this date, and then you can make the application. So it just depends.
Again, always depends, but always good to have these examples so people can think a little bit more how it applies to them. So thank you. And I think we're now entering the more niche questions. So an interesting one in the Q&A is that someone has a biometric identification that does not have an expiry date, and their application form is asking for the expiry date, but they don't have that. What do they do?
Yeah, sorry, I did, and I said I was going to come back to some of these, and I'm glad you're flagging them up to me, because I think there's someone else who said, and even some people who have potentially non-biometric proof of indefinite leave, which will go back even further, because biometric cards haven't always been around. What do you do? So I think, so if there's a field in the form that is you have to fill it on. You can't proceed without filling it in, but you don't. But like in this case, is impossible because there is no correct information. So what I would probably do is I would put in like a fake date, like so the 1st of the 1st 2025. I mean, it would have to be expiring in the future. And then when you get to the end of the form, there's a section that says, is there any additional information that you would want to present? And sometimes I have to write in that, well, you need to refer to the letter, because I have to explain lots of complicated things, or ask for discretion. I say, well, see the letter I've written for you. Or you can put in that box about extra information. You could say, I've had to write this date into the part about expiry because it doesn't have an expiry. So I've done this in your form because you wouldn't let me proceed without putting that information in, but it's the wrong information because the actual information doesn't exist. So that's how I would do that. Okay,
that's very interesting. I had never thought about that, so good to learn something new as well.
Yeah.
Another
the forms are obviously ask for standard information, and there's just not, some situations just don't fit that, which is why you have to then say, I've done this, but this is why I've written this information, even though it's not right.
Yeah, all good that there is that space for some clarification. Another one that I had a quick look online and I didn't see it, but someone says that they have passed the ESOL Skills for Life, and they have been told that with that they don't need to take the Life in the UK test. Do you know about this ESOL Skills for Life test?
Yeah, so I've certainly heard of the ESOL Skills for Life test. I think it may have been something that was used by the Home Office in the past for certain applications, but to me it is definitely not the same thing, or it doesn't have equivalence to the Life in the UK test, and there's absolutely nothing in any of the guidance that I have looked through which alludes to it being acceptable. With sometimes you have to say you can't. I'm not going to be 100%, but no, I unless someone showed me something that clearly said this could be used because it was acceptable in the past, I'm going to say no. It's Life in the UK test these days.
That makes sense. That's what I posted the link to the exemptions, and that's not included there either. I mean, I do have a question that's not directly about citizenship in the Q&A if you want to have a go. It says, I am an Indian national and I work in the aviation field with holding a bachelor graduation. And how can I proceed to get permanent residence or work permit in the UK? Think that might be, don't know if that's in your scope to answer or not. No worries if not.
I mean, I can answer it sort of in the very general context, which is, I mean, I get the feeling this is someone who potentially doesn't reside here at the moment. So in which case, if you're looking to use your skills to come for a work permit in the UK, then you would need to look at the working routes to come and reside here. So, which for most people nowadays is something called the skilled worker visa. There are some other working routes. There is something that's been recently introduced for Indian nationals called the sort of Indian Professionals, Young Professionals Scheme, but it's only open for a couple of thousand people, but that's a possible route that allows working for a couple of years in the UK. But essentially, what I take from this question is there's someone who wants to come to the UK to work, and so the thing to you generally would advise to say, well, you need to have a sponsored job. There's very little scope for people to move to the UK and seek employment once they're here. Now generally you have to be sponsored to come here by a UK-based employer. So this person will need to look into that.
Yeah, that makes sense. Thank you. And I guess our final question in the chat now is for those that have EU settlement scheme under the Zambrano carer route. How many years of proof do they need for naturalization?
So there's no reason why they wouldn't be subject to the Zambrano carer wouldn't be subject to the same 5-year or 3-year qualifying if they were married to a British citizen. They probably wouldn't be a Zambrano carer if they're married to a British citizen, possibly in some limited scenarios. But yeah, so there's no reason why you wouldn't be looking at the same 5 years or 3 years if appropriate in terms of the qualifying for residency. If you are a Zambrano carer and you have had difficulties potentially with the Home Office in the past obtaining status and having to fight with the Home Office to get your Zambrano status, if you have a complex immigration history, you might want to have a conversation with someone like me, because you want to know that nothing in your past is going to upset the process. But you know, the general rule, as I've said before, which is if you Zambrano carer with settled status, indefinite leave to remain, the Home Office general policy is we don't go before that and look into it. But if you have had issues, because obviously Zambrano carer it's a tricky route, and people often will have had difficult fights with the Home Office to get their rights approved. So it might be worth that conversation to make sure nothing has gone on before you'll grant a status that would impact.
Sounds good, Claudia. I hope that was that we could understand that. And well, I don't have any more questions. The ones that I've received through various platforms have all been answered. So I guess the final question is, as you said, like sometimes people will need to speak to an immigration advisor. Where should they be going to? We can send some links as well tomorrow in our follow-up email, but if you can make any suggestions where people can look for information.
Yeah, I mean, so as I said, like the overriding thing is just to make sure whoever anyone speaks to is regulated. Within the 4 nations of the UK, that might be a different body, because Scottish lawyers are regulated by a different body than lawyers in England and Wales and Northern Ireland. There's an organisation called the Office for the Immigration Services Commissioner, the OISC, who are nationwide, like a UK nationwide body. And there are others, so that's not the only ones. But so it will partly depends on where you live, who you'll be speaking to, and who they might be regulated by. But as I say, like the OISC website has lists of regulated advisors, solicitors in England and Wales, Scotland, Northern Ireland, all on the websites of these law societies that cover those. The Immigration Law Practitioners Association, something called ILPA, has a register of advisors. Any one of these bodies, should be able to find someone who can give you that regulated advice. But and they will tell you, anyone who can't tell you who their regulator is not regulated, because it's not a difficult question for someone to answer. So you can ask them when you contact them. But yeah, and as I say, like I think it's because nationality. Just one thing to say about nationality law is it isn't covered by legal aid in England and Wales, certainly, which means that in terms of free legal advice, it's quite limiting, because legal aid firms can't claim any money for advice on most naturalization type applications. Some organizations like Citizens Advice, the Law Centers Network, can provide free immigration advice, but it does depend on their services, and individual ones in different areas will have different services, and of course, because it's free, it can be stretched. So in terms of sort of free legal advice, it can be quite tricky to find any, I'm afraid to say. But yeah, but if you are going to speak to an advisor, it's mainly about making sure that they got that regulation to help you.
Thank you. And well, we hope that this is a starting point for many of you. This, as you know, has been a free webinar, and you're speaking to a very qualified immigration advisor. We've been working with Chris for a few years doing informative webinars like this. So Chris, we're really, really grateful for your time being here with us. We're grateful to everyone who's joined us. And you will receive an email from us at Migrant Democracy Project tomorrow morning with all of the links that have been posted in the chat now, and others as well. And as well as a link to this recorded webinar. So you can watch it again, you can take notes, you can share it with family and with friends. And finally, as I said, please check the links that we sent as well, so you can keep in touch with us. We will continue hosting different informative webinars like this, and we also ask that you join some of our campaigns so that we can keep making progress in areas like this, getting more of us voting, potentially voting for the citizenship costs to go down, because it is quite expensive. But for us to do that, we need more of you alongside us and joining our campaign. So thank you so much for joining us tonight. Chris, any final words?
You've summed it up beautifully. Thanks, Laura. No, thank you for inviting me, and thank you for everyone for challenging my knowledge on the subject, the questions of action. But no, it's been a pleasure, and I'm very, very grateful to be able to hopefully give people some information they can use going forwards.
Also, thank you. Also like to say thank you to my colleague Alexandra, who is right here next to, there she is, I think helping me with links. Do you want to say anything, Alexandra?
No, just to say thank you everyone for attending. We have an echo because we're in the same room. Sorry about that. And I've been answering some of the questions in the chat and post some of the links as well. So yeah, thank you everyone for attending, and just sign up to our Migrant Democracy Project website. I posted some links just now at the end on our campaign, and how to sign up to receive newsletters and emails about other events happening in the future. So we'll host similar events discussing a range of topics from voting rights to citizenship and to other topics of interest to various migrant communities in the UK. So stay in touch with us via the forum, the website, and of course you can find us on all the social media platforms at Migrant Demos on Twitter, Facebook, Instagram, and even TikTok.
Exactly, we're everywhere. So stay in touch. We wish all of you a very good evening and see you at a next webinar or online. Take care. Bye.